first of all, I want to thank all the participants to be here with us in this fireside chat, where we are going to discuss lots of on IP thing and what are the legalities are you need to rely on, and what will be the other aspects, what you need to be serious about, what you not to be serious about, right, when you are planning on a very early stage. So thank you so much for the participating in this session with us. I would like to welcome our today's speakers, Mr. Harsh Pangi and Kevin Fournier. Welcome to this session. I'm very grateful to have you here for this fireside chat. Before starting the session, I would like to brief about both of the speaker profiles so that our participant would get to know more about you guys. Okay, allow me. So I would brief about, first of all, Kevin. He's very good in a practice involves which where the uh, patent prosecution, filing, intellectual rights, wherever you need some opinion work on patent validity or infringement, patent portfolio management, and advice on patent assertion. So he's very good at, and I'm seeing that we are gonna have lots of today about that. Also, Kevin practices in a practice involves providing advice and counsel on technology and business traction as well. So, in such as IT service agreements and joint development agreements, venture agreements, purchase agreements, lots of other, right? So,
yeah.
Yeah. So, thank you so much, Kevin, to be here with us. So we are moving towards our another speaker of the day, Harsh Pangi. Thank you so much, Harsh, to be here to make this session so interactable. It's gonna be very good. I'm just having that vibe. So I would like to brief about Harsh that we are at Headstart had engagement with Harsh from a very has a very good repo, right? Because we have very good experience to work with Harsh. He is a founder of IP-FY and also he's a patent agent at Indian Patent Office. He has been innovation coach at Institute of Inspiring Innovation as well, and his focus areas are relying in in a startup mentorship, innovation coach, and intellectual property rights, what you can leverage as a rightful in a Indian ecosystem. So thank you so much, Harsh, to be here with us. I'll hand over this session to you guys. Thank you so much.
Yeah, thank you, Bagdasi. Thank you for the introduction. And pleasure to be here, and hopefully the participants will get to learn something new from today's session. Definitely, there's a lot that they can learn from Kevin. He is more experienced and he's been in the field for quite some time. So, Kevin, you want to start or you want me to take the lead?
You can take the lead. I'll just say that these are just ideas that we had that you might want to jog your memory with, like maybe something here will tell you, oh, I have a question about this, or I'd like to know about that. So these are just a broad collection of different topics that we deal with every day that we think that startups would be interested in knowing about. So maybe this would tell you, oh, I want to ask a question about that. That's what we're intending, by this chart. You can carry on.
So I think what we can do is we would love to know first a brief about your opinion and views on the IP as well as in the SaaS domain, Harsh, and then we can also have a few input from the Kevin side on this particular domain, which is one of the very like a domain where most of the people need to have a lot of insights and input. So we will go with first Harsh from your side and then from the Kevin side, and then I think we'll also have some questions which I think Bagdasi will be putting up upfront both to you guys.
Yes.
Okay. All right. Sounds good. So I'll maybe just begin the session by introducing what intellectual property is and what are the different types of intellectual property that can emerge out of SaaS applications or software applications. So we'll define IP. IP is nothing but creations of mind. So whatever your mind is able to conceive or think of can be referred to as intellectual property. So this can be in the form of ideas. It can be in the form of creations, expressions. So there are since your mind is able to create different types, right? There are different types of IP to protect each type of creation. So when it comes to software, it can be broadly protected via patents, copyright, and trade secret. So patents, will briefly define what patents are. Patents are nothing but exclusive right for a technical solution. So you have a problem and you may have one or more technical solutions. So you have a monopoly or an exclusive right to that solution when you get a patent for it. So patents generally will exclude others from few activities like making, selling, offering to sell, or importing the patented invention. So if you patent your idea in a specific jurisdiction, and when I say jurisdiction, it's in a specific country, you can get protection in that specific country. So you can exclude others or prevent others from activities like copying, making, selling, offering to sell, or even importing the patented invention in those jurisdictions. Copyright broadly protects the software code and generally protects expression of an idea. So patents protect the idea, whereas copyright protects expression of an idea. And when I say expression of an idea, it can be in the form of art, literature, poem, book, right? And when it comes to software, generally it is code that can be copyrighted, website contents, and then if you have any brochures, manuals, all the content can be copyrighted. So third type of intellectual property under software is a trade secret. So any compilation of information that can be kept a secret, right? It has an economic value and it gives an edge over a competitor. That compilation of information is referred to as a trade secret. So trade secret, there are three basic requirements for any piece of information to hold the tag or carry the tag of a trade secret. One is that the information should be secret, or the onus lies on the owner to keep the information a secret. Second is it should be known to a limited number of people, which is why it is a trade secret. And third is it should have some kind of economic value, right? Only if a piece of information has some kind of economic value that can generate some kind of a revenue for you against your competitor, then that piece of information would qualify as a trade secret. So Kevin, would you like to add something to what we discussed here?
I think that's a very good summary of the three types of IP rights that cover software. There's also trademark, of course, that covers the name of the product that your software as a service product. If you have a name that you identify with that product, then that name can be protected, and then nobody else can use that name for software in the field that you get protection for. So that's another right. Now that we've covered the rights, I guess the question would be what can we do with them, or what are they for? And the main thing that these IP rights are for is to give you a competitive advantage for your business, so that if you come up with something clever, whether it be a name that's very unique, or whether it be the whole software itself, your whole product, the source code, for example, or whether it be a technical innovation that you've solved, like a problem that you've solved that a patent has been granted for, then nobody else can use this without your permission, or at least you can notify them, or they can see it themselves in a public register. If your startup gets going and you file some patents, then if people know that you're in a certain field, because that's what you publicize, then people could go to the patent office website and see what patents you filed. And then they would know when they look at the patents that, hey, this company is already there in this market. They already have protection for the key innovations in this market. It will be hard for me to enter this market. I will need to get a license and get their permission. So you as a startup would be in a good position. You would have patents already filed. You would be sitting there waiting then for companies to come to you to say, I would like to have a license, and then you negotiate a license agreement, a contract with them where they pay you to use your patent rights. If you agree to let them do that, you may want to be the only person using that, and you can do that as well. So that's kind of what IP is all about, is securing you a competitive advantage for the ideas that you come up with that are yours, like the creations of your mind. So there's different scenarios where IP comes up in the business of a startup that both Harsh and I have seen, and they range from at the very early days when you have employees and consultants to help you write the code. It's very important to have a contract in place where the IP rights that the employee or the consultant creates is owned by your startup company, because that's the only way that you can then own it. If you don't do that, if you don't have the right contract wording in place, then maybe the consultant, for example, would walk away with the IP rights, and then you could not benefit from them. So that's one way that we see IP issues coming up. The other way is once a software development is going to start, then there are lots of IP issues to consider, such as making sure that if you use open source software, for example, that you look at the licenses that apply to each piece of open source, and make sure that license actually applies for the situation that you intend to use it in. Like for software as a service, you will be having the open source be sitting on a server and not distributing the software, to your customers, and the customers would access the software remotely. So then you need to check the license terms of each open source package and see if it works, for you. So those are just some examples of things to look for.
Yeah, those are great insights, Kevin.
Yes.
So coming to, so there was one, there has been one burning issue in the Indian ecosystem about patenting software-related inventions or filing software patent applications. So I'll just briefly touch upon that. So firstly, there has been a lot of changes in the last few years. And when I say lot of changes, when it comes to computer related inventions, the patent office has taken steps to revise the guidelines, as well as the rules, as well as the specific sections to incorporate software related inventions. There have been computer related invention examination guidelines that have been provided to the examiners when they to handle software related inventions. So there are a few basic criteria that the examiners look for, and this I think is applicable to pretty much every jurisdiction when it comes to when you file a patent application, let's say in the US or UK or India or any other jurisdiction in the world. There are four basic requirements, right? One is the novelty, what is new about your invention or your innovation. Second one is the inventive step. I will come back to inventive step later, because this is the most important step based on which the patent application would be granted or not. Third is the utility, which means that whatever you're inventing or innovating should have some use in the industry. So let's say you invent a pen which doesn't write, then you cannot get a patent for it, right? The pen is meant for writing. So, and I have also seen a lot of times, most of the startups, right, they're trying to file patents based on a new use, right? So just because you're using the innovation or the idea or the solution in a new area, that will not get you a patent application, right? I'll give you a very simple example of the utility aspect. Now, let's take a screwdriver, right? So what is the primary use of the screwdriver? To screw and unscrew, right? Screws. So now if you say, I use the screwdriver to open the lid or even stir my coffee, right? It is a new application, it's a new utility, but that will not get you the patent, right? So startups have to be mindful about this aspect. New utility or new use cannot get you the patent. The most significant criteria for evaluation is the inventive step. So it's referred to as inventive step in India, technical effect in Europe. I think it's called inventive step in UK as well, if I'm not wrong. Correct, Kevin? It's referred to as inventive step, right?
Exactly, yes. Yeah.
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 And it's referred to as non-obviousness in the US. So all mean the same thing. And when I talk about inventive step, there should be a significant transformation. So when it comes to software related applications, just calculation. So the reason the act says that software per se, algorithms per se, or computer programs per se are not patentable is just by having the step of a calculation or a determination will not get you the patent, right? Now you're doing some kind of calculation. What do you do with it? After calculation, how do you use the output of the calculation? What is the output? How do you use it? How is the software application using it? Is there any inventiveness involved post calculation, post determination? So some kind of data transfer, data transformation. So these criteria are the ones that will be primarily evaluated, and then the patent office will decide whether to grant or not grant the patent. So the fourth and the most important requirement is sufficient disclosure. So this is where experience and expertise comes into picture. So I was previously employed with SAP. I have extensively worked with European as well as US patent attorneys. And I still remember my training days. I used to be up some days late into the night, or maybe early into, just wake up early morning to understand how the patent application should be actually written, right? And when I actually started understanding and appreciating the time and effort, right? When I put in the time and effort and understood the actual meaning of sufficient disclosure, that is when I realized its importance. And when I say, when there is a requirement of a sufficient disclosure, it means that there should be a proper structure to your software-based invention in the patent application. So this is one more important criteria that patent offices see. So a lot of patent applications get rejected as being abstract because they do not have proper support or underlying structure in the patent application. So I'll give you a very simple example again based on my experience. So you say, okay, means for generating a signal or means for doing something, right? How is the signal being generated, right? there should be some structure to it. So are you using a hardware component like a signal generator, or are you doing some kind of computations or some kind of transformation to generate that signal? Those details have to be there in the application. If those details are missing, be it any jurisdiction, US, UK, Europe, or India, I can guarantee you that the patent application would not be granted. It will invoke different sections, different laws, different rules of the respective, patent laws in those specific countries, and it will prevent from getting the patent granted. So what do you say, Kevin? What are your thoughts on this?
Yep, that's exactly right. Those are all criteria that you have to meet in order to get a patent, and they are the basis for making arguments to the patent office. When the patent office feels that there is some problem in one of these areas, they will raise the problem, and then it's up to the applicant, with the help of a patent attorney, to respond using some of these are very well-known traditional responses to each of these points, to bring a counter argument to any arguments that the patent office makes. And then like inventive step, the obviousness of an invention is something that you can argue for a long time, whether something is obvious or not. And so you present your best argument, and then you hope that you can convince the patent office that your argument is correct. So that is what these criteria are. They're legal factors that you have to satisfy to get a patent, and they are not straightforward. Like in technology, in there was an answer usually. That in engineering there was always a number, or there was a specific answer. But in the law there is really no clear factual answer. There is arguments that you can make to try to persuade somebody to come to your answer. So that's why patent attorneys are helpful, because we can help to guide you in these 4 areas here to get to the right answer for you, so that you can get your patent granted.
Right. Okay, so thank you so much, both of you, to brief us about the very basics of the IP patents terms and what are the things needs to be taken care of and all. So this is we are having a participants more in a SaaS domain, a software-based startups are here. So I have a question behalf of them, that what could be the new forms of IP that could be helpful in this SaaS domain?
What would be the new forms of IP
Yes.
that would be helpful in
this SaaS domain, software and service domain?
I think it's the 4 that we've mentioned. Harsh has mentioned. Copyright is very important in the SaaS domain, because you're putting software onto a server, and copyright protects the expression and of the code, so nobody could copy it, and so that that's a key one. But it's just the 4. There are no new ones. That it's the 4 traditional IP rights that protect SaaS software as a service. Yes.
So just to add to that, would like to also mention that copywriting software is generally recommended if you know that the software code is not going to change. This is another very important criteria, because the moment you add content, maybe even a single line of code to the copyrighted code, your original copyright will no longer hold good. This is one more criteria to keep in mind when you're copywriting the software. So typically, if you know there is a stack, let's say an operating system which uses a stack of code which is never going to change, and you are going to only add libraries or build libraries on top of it, then it makes sense copywriting that kind of software. But if you foresee the code being evolving, developing, modifying over a period of time, again, I wouldn't recommend filing a copyright or protecting your software via copyright.
Sure. Thank you for the insights. So basically you briefed about that, why it's important and how we can proceed for the get the IP rights on a SaaS startups, right? But what are the tools are there which can help these early stage SaaS startups to build or develop the strategy in IP?
I think you can go to Google. There's a lot there in terms of just seeing what's out there in terms of a name. Like for example, if you have a name that you'd like to call your software, it's helpful to just go onto Google and see if anybody else is using that name for something similar. And there's also patents that you can search for on Google, or the website of the patent office in the different countries. Like the USPTO has a really good website for searching for patents, and you can put in certain keywords and you can see samples of patents that other people have in your area. So that's kind of an interesting way to just find out what patents are and what they look like. So yeah. And if you have any particular competitors in mind that are already out there, you can search for their names and see what patents they have.
Okay, we can just get to the particular attorney man and they can guide us in a more deeper way. Yes.
Yeah, exactly. Yeah.
We have a couple of questions in the chat. One is from Krishna Raju. What are the possible ways to register? Example, somebody copy the screens of features. How can we get protection for them? Kevin, would you like to answer that?
Yeah, I mean, if somebody, like if you have a website and somebody copies it and uses the exact display format and the images and the text and anything that you create, like a website, any text or any document like that is yours, and you have a copyright in it automatically. So if somebody were to copy that and take that from you and then use it themselves, then they would be infringing your copyright automatically. You don't even have to file for any protection. So in that case, you could write to them and stop them, and try to stop them by writing to them first. With the help of an attorney would be helpful to use the right terminology. But yes, you would have protection from that. Nobody has the right to take your authorship and use it without your permission.
Yeah, just to add to that, Kevin, I think the question also encompasses UI features. That's what I understand. When somebody is trying, let's say somebody has some certain UI features, the way the UI elements are placed on a screen, right? On a web, on maybe an application or just a website. So one way to protect the UI features is through a design registration, right? But then again, the moment you change the element, specific UI element. So let's say, for example, you have a login page with 2 text boxes and one login, or 1 or 2 login buttons, right? 1 login and 1 cancel, probably something like that. So the moment you interchange the UI elements, let's say you move the buttons to some other location, you move the text boxes to some other locations on the screen, your original design registration will again not hold good. So the moment there is change, right, your original rights will no longer hold good. So I hope broadly, with reference to UI features, it is design registrations, and with reference to the content of the website and the way the content is organized, whatever you put in the website, I think Kevin has answered that as well. Hope that answers your question, Mr. Krishna.
I guess yes.
Okay.
So
So there is
Yeah, there is
Next
one more
question.
question from our participant only. So, Amia wants to ask that does a piece of software to solve for a problem, the way the software does it, qualify for IP? So, can you talk about how can one prevent the variations from getting outside of IP?
Would you like to start, Harsh?
Yeah, you can take it, Kevin. I will
Oh,
add to it. Yeah.
Oh, okay, okay. Yes. I think the question is. Tell me if I'm wrong. That the software innovation, like a technical innovation, how is the best way to protect it using a patent? And how can variations be protected? Is that?
That is right. Yes.
Yeah. Okay. Okay. Right. So it's very important that you phrase your invention as a technical problem with a technical solution that you've come up with. So something that perhaps makes the computer work better, or something that affects something in the real world that's technical, like maybe improving a manufacturing process outside of the computer, or helping the flow of liquids work better, something technical, making the computer store data in a more compact form, or something like that. It's very important that a patent protect a technical innovation that really is of interest to the engineering world, as opposed to a financial innovation, like a way to reduce prices in a certain market, or something like that. Is kind of hard to patent, because you have to always phrase it as a technical solution to a technical problem, and technical means really something of interest to engineers, something that you'd find interesting on the syllabus of an engineering university, for example. So that's the kind of thing patents protect. And when it comes to variations, when you file a patent, you have to come up with a certain scope of subject matter that you want to say is your invention, and you want to say it in the broadest way you can that still covers everything that you've considered to be critical to your invention. So just the minimum features, technical features that come together to solve the problem, and not optional ones. So the optional ones would be where variations would come in, and those are protected also in the patent, but as dependent features that you add at the end of your statement, where you capture the heart of the invention in the first claim, as we call it, which is a legal statement of what your invention is. And that would be the absolute essential features, the ones that you could not do without and not solve the problem. But then you would have these dependent claims after that would be optional features that would be different ways of solving the problem that would improve upon the first claim that you have, which is the essential or heart of the invention. So yeah, it's really all about technicality. You need to come up with a story, and as patent attorneys, we would ask you, please tell us the technical story of your invention. First there was this, and it wasn't very good technically because of this, and now we came up with this way of solving this technical problem, and now we have this great technical result that it works much better because of this. That's the story that you kind of have to tell to get a patent.
Yes,
Great.
yes.
Great.
Yes. So we have another question from Amia only. That what is the importance of trademark, and when should one can use it? Like, how does it differ from IP?
Okay, well, it's the very specific name that you come up with that identifies your business or your product, that makes people think right away of you. That is what, like Apple or Microsoft or IBM or SAP. When you hear Windows, Linux, when you hear these words, these names, you think of a certain source, right? That is the whole purpose of a trademark. You want people to it's a shorthand, like a little package of information that, one little name, and they think of your business, and they think of your product, right? So that's what you want. You want to come up with a name that will be a shorthand for your product. So that little package will be very valuable as a piece of IP, because when you hear Windows, people don't, in the computer world, you don't think of the window in your house, you think of Microsoft Windows in your operating system, right? So that is very valuable. So I mean, you'd like to have that in your startup. That would be a great thing to have, a name or a little nugget of information captured in a name that then makes people think of you, right? That is so valuable to build.
Right. So
Yeah, one very simple example that I would like to throw in where people can relate to it the most is the Nokia connecting people. So it's a classic example that I think most people here in India can relate to. So that has been trademark, where the name is Nokia and connecting people is an expression. So both have been trademarked and can be used. So the way one trademarks it, either collectively or separately, it can be used accordingly. And to answer the second part of your question, how does it differ from IP? Trademark is a type of IP. So all that we discussed, right? Patent, trademark, copyright, trade secrets, these are different types of IP. They are not, they don't differ from what IP is. Again, a very simple example. You have cars, you have hatchbacks, you have sedans, you have SUVs, you have mini trucks, minivans. These are all different types of vehicles, right? Likewise, patents, trademarks, copyright, trade secret are all different types of IP. So hope that answers your question.
Yes.
Thank
Okay.
you.
There is a few questions from Yatendra's side as well. So I want to address Yatendra over here and explain your question to our speaker.
Yeah, sure. So my question is with respect to SaaS software that we develop. So since the code is ever evolving, it seems to me like we can't get our code copyrighted ever, right? Because we can't stop enhancing it, we can't stop modifying it. Then what's the point of copyrighting the code? And does it then even applicable for SaaS?
Okay, so you're saying that the software that's running on a server, the software as a service, is constantly evolving, right? So what is the point of protecting it at a certain point of time?
That's correct.
Yeah. Oh, okay. Right. So, well, copyright protection is automatic. There's nothing to do. So when you modify, when you create it on day one, and it does what it does on day one, and then on day 10, when you've made some changes, you have protection again on day 10 for the change version. Automatically, as soon as you create it and install it onto your server, you have protection for the new version on day 10. And then day 30, when you've made even more changes, you again have protection automatically. At any point in that chain, during that month, if somebody steals your code somehow and starts to use it without your permission, you have legal rights to go after them and stop them at any point in that 30 days, no matter whether they took it at day 10, day 20, or day 30, or day 0 at the beginning when you first put it on it. No matter when they took it, you will have protection. So yeah, you don't have to do anything to get copyright protection. You will have protection, and so that really is the way that this is handled.
Okay, so that's what even my understanding was. But then Harsh just like in the earlier session said, like even if you add a single line of code, then the earlier copyright becomes invalid. So I'm a little confused here.
So if you register, so what I meant is, if you register, let's say you have your initial piece of code is 4 lines, right? By default, you hold it. Now you register the code with the Copyright Office and have a number for it and say, okay, this is the original copyrighted code. And now subsequently, if you add a line of code, or let's say that snippet, 4 lines of code becomes a part of a bigger piece of code or bigger piece of software, right? That will not take the copyright that has been granted by the office along with itself. So you'll have to apply for a new copyright. You get my point?
So you mean to say that there are two types of copyright, unregistered and registered?
Yes, registered is when you register. Unregistered is by default. So when you create the code or when you create the content, not only code, any type of content like videos, pictures, cartoons, the moment you create it, you hold a copyright to it by default. Okay. Now the issue comes if you want to enforce it. Like Kevin mentioned, let's say somebody steals your piece of code, right? What document do you have to prove that you hold a copyright towards it? The whole point, the whole exercise of registering for a copyright is you will have a proof, right? You will have a proof from the government saying these 4 lines of code is protected by copyright and it is recognized by the government and there is a certificate that was provided for it. Only when you go to enforce or when you go to litigate, that is when the registration would kick in. The registration would hold value. So if you don't intend to litigate, if you don't intend to go and enforce your rights on someone, you can still hold the original copyright, keep adding lines of code and put the copyright symbol, your name and year of creation of the code and still hold the rights. But then if somebody steals the way you would want, if you want to go behind them, you should have valid or legal rights. And those legal rights are nothing but that you get when you register it with a copyright office. So that's how the process works.
Right. So you can do it at the last minute. You can you can go along with your business, happy and, developing your code and nobody's stealing anything from you. And then if you know that somebody's stolen stolen your code from you after a certain point of time.
So Yatendra, did that answer your question?
Yes, sir. That helps clarify the doubt. Thanks for that.
Yeah. Okay. So we'll probably take the next question, which is related to patenting AI algorithms and cost for it. Probably we can have a offline discussion for that. Krishna, you can get in touch with us. The contact information is already on the slide, which was being shared. So you can get in touch with us and we'll help you with.
We'll share the speaker details as well in the WhatsApp group as well. So everyone can get in touch with you guys and have their queries resolved, right?
Yes. So there's one more, I think, by Yatendra. It says, to me, patents always seem to be time consuming and costly operation. It's small startups can't afford, especially when we ourselves are not sure if the stuff we want to get patented can actually be patented. It's a good question and needs a very deliberation and elaborate answer. To keep it short, did Kevin join? Probably he can take it. So we have one more question from one of the participants, and so it says, to me, patents always seem to be time consuming and costly operation which small startups cannot afford, especially when we ourselves are not sure if the stuff we want to get patented can actually be patented. So your thoughts on that?
Yeah, I think the best to get advice from us as to whether it's worth patenting is a very valuable thing to do. Because we've seen, Harsh and I have seen so many different situations and read so many court cases that we know we have a very good idea, what can be patented and what can't. So it's again that story that I mentioned a minute ago, that technology story. If you can tell us that story, and it sounds like to us like it will pass the test, then there's a really good chance that it can, and we can help to reduce costs. Yes, the costs, I recognize that costs are expensive for patents. It's because of the background and the experience that you need to put together a good patent that will pass the test before the patent office and that will give you some decent protection, because it's really easy to file something that would fail or that would be very weak in protection. Like you can throw everything into the patent and have a very long, claim, for example. We call it a claim. It's what you have the protection for. It's very easy to get a patent with a very long claim. They call it a kitchen sink claim. You throw everything in, and so then but it's worthless because it's very, very narrow. Nobody's going to infringe that because it's too narrow. So that kind of help. You have to pay for the experience of getting you past all the tests and also giving you something that is not worthless and is very valuable. But I mean, we can save, but that doesn't answer your question of how to keep costs down and for a startup that doesn't have much money in the early days. And that's the time when you need to protect yourself, is in the early days, because if you go out and make it public, it's too late to get the patent. So one suggestion I have is that you talk to us for a short time, come up with a story as to why you have a technical innovation that solves a technical problem and you meet that test that I talked about earlier of technicality. We can then tell you very quickly, that sounds like it's a good idea. I think that will fly. And then we can kind of guide you to put together something like a skeleton, to save you money. We can say, please write something that answers this question. What was there first, maybe? How were things done, before? And then tell us what was wrong with what was done before. Then tell us what you've come up with and draw us a picture of the elements, that come together to solve this problem. Draw us a flow chart of the steps that the software follows in solving this problem, and then explain those two block diagrams, the block diagram and the flow chart. Explain it. Tell us the steps. Write it out for us, right? Then if you could do that for us, and then you could keep your costs down significantly, because then we could, Harsh and I could look at that and we could then put together something very much quicker and save you a lot of money, and we could give you a quote for a patent that would be lower than what you're used to. If you so it's all about sharing the work. I mean, if we do all the work, then of course it takes more of our time and more of our money. But if you do part of it under our guidance, like I just said, starting with the story, a very quick meeting with the story, tell us your story of your technical invention. We may then tell you, sorry, we don't think there's much chance, or we may say, that sounds great, you've got a great chance, So yeah, that's my answer to that. I feel the pain of the low budget. I know I'm a startup myself, and my company only started about 6 or 8 months ago, and so I know what it's like. So anything that will save money would be very, very valuable. So that's my idea. That's my suggestion.
Yes. Thank you, Kevin.
One more thing, can I add one more thing to this, what Kevin said? You could consider filing a provisional patent application. Provisional patents will, drafting and filing a provisional patent application would typically cost lesser than a complete or a non-provisional. So the way the provisional patent application would work is it would act like a placeholder, right? Let's say we filed a provisional patent application today, which is January 11th, 2022. We would buy time for a year, right? So we would have time till Jan 11th, 2023, on or before which we can decide whether we want to file a complete application or not, right? And whenever we file this complete application within this 12-month window, it would be as good as filing the complete application today itself. So that is one more strategy that I generally advise startups, because that way they can split costs or save costs, where they can file provisional and then 6 months down the line they can decide, right? Because in 6 months even the startup will have clarity, be it on funding, be it on the product features, if the product has evolved, if there are any additional functionalities that need to be added. So all that can be done and put together and filed in the complete application. The best strategy is to file a provisional, and by that time of 1 year, and then decide whether you want to go ahead and file the complete or not. So generally, the startups that I work with, I recommend them this strategy. Whenever there is a confusion or they are in a dilemma that they are still not ready with the product, or they want to add some additional features, maybe 3 months, 6 months down the line, they are experimenting with certain things. So provisional patent is a great tool that one could use and get a date, filing date, and then within that 1 year, make a decision to proceed with filing a complete or not.
Thank you so much, Harsh, for explaining such a nice answer for the question. I would like to move ahead with our further questions because we have a lot to cover yet. So I want to ask that, you guys have been vast experience in mentorship regarding this IP rights and all things, right? So I have a question for you, that what are some of the challenges you feel startup face these days when it comes to due diligence side of the part, right? So please.
What are some of the challenges? I think that the big one is the one we've just heard about paying money for the legal services. That is a big. I would not be honest if I didn't say that was that was definitely included. And we need to as lawyers, we need to find ways to help you with that, because that is, if we're going to work with startups, then we need to help you with that, because we can't just tell you this is the price, this is the market rate, and everybody pays this amount, and that this we need to come up with ways to help you to achieve that goal without expecting you to spend huge amounts of money right away when we know that it's not what you can do right now. So that is one challenge. Other challenges are when it's all good when you're working alone, when your company is by itself in its own setting with just employees and stuff working. But once you start working with other parties, like maybe collaborating parties, like if you're going to do R&D collaboration or develop code together with a university, maybe, this is when IP really becomes important. So I see it, one of the challenges for startups in making sure that you do things legally the right way to protect yourself, so you don't give away or lose rights when you start working with others. Like maybe there's a collaboration agreement that should be put in place with the university that you're going to partner with, so that any IP rights that are created during the collaboration are structured in the right way, so that maybe in a fair way. Maybe it could be joint ownership, or maybe it could be that one party owns the rights in a certain field and the other party owns the rights in another field. Those are two different ways that we've dealt with this. Maybe the university would get a free license for research purposes only, academic purposes, but not for commercial purposes. So that these are other ways. And one of the important lessons is that before you work with other people, you should document all your rights. So that's a challenge. Just to make sure you do everything right before you start working. If you have an invention and then you already had it before you start to work with somebody, if you start to work with them and you just had the idea but you don't have it written down, you don't have a patent filed, maybe the best thing is to file a patent, of course, because then it's clear that you had it before you started work. But if you can't file a patent, then at least if you had some record to write it down and timestamp it with a date, and then when you start working with the university, then you if the university would say later that this was developed during the collaboration, so we have rights under this, then you could prove it, by showing that you either filed a patent or that you have timestamped information, so that's another challenge. And of course, there's the challenge of looking ahead to being acquired. This is, the holy grail maybe sometimes, you know, like you get bought and you can exit and then you walk away with a lot of money, you know, from starting up a business. So the buyer though, I've been involved in many of these transactions. The buyer will look at your startup and they will look for problems. You know, that's what they will be. They hire people like us, you know, to look for problems. You know, turn over the stones. You know, look at you know, for anything that you've done wrong. You know, have you talked to a university without protecting yourself? You know, have you hired a consultant to write some code, but you did not get the right contract in place? That consultant may have rights, and then when the company buys your company, then the consultant could then go after the buying company and say, hey, I actually own this code, not the company that you bought. So you know, all of that, I mean, is a challenge. So, you know, we often get involved to help startups to guide you through the beginning times of your company to make sure that you have everything done the right way, with software development guidelines, for example, to do things in the right way, to tick all the boxes in the right way legally, so that you're not missing anything that the company that wants to buy you is going to find. And then point, you know, like one of the key ones, just an example is that's come up in my past examples, you know, work is that a startup has hired a software developer from a competitor, and he at the competitor. The software developer has seen the source code of the competitor, and then he or she is hired into the startup to develop the same type of code that the competitor had, having full knowledge and experience with the code of the competitor, and then starts to write the code for the startup, and then sometimes inevitably it's very difficult not for that developer not to subconsciously even take ideas and ways of expressing that code and creating it again, you know, for the startup, and then the competitor could bring a claim of trade secret or copyright or both, misappropriation against the startup. And then when the buyer is looking to buy the startup, and then ask the questions, which is a standard question for a buyer buying a startup. Have you hired software developers that came from a competitor within a relatively short period of time? But, you know, like maybe 2 or 3 months they were working for a competitor, and then, you know, they 2 or 3 months later they start working for you, writing the same type of code. That is something that a company would look for. So that's a challenge I think that startups have, is to make sure that you're doing the right thing, and we can help with that, you know, by guiding you and checking that you're doing the right thing.
Right.
Okay, thank you so much, Kevin. Yes, Harsh, you want to add something?
So one burning issue, I would call it a burning issue, because people rely on Google searches. And me and Kevin have been discussing about this for quite some time, relying on what Google provides as a source of information would not be recommended sometimes, because there have been instances where I have come across blog articles that were written by non-IP background right, bloggers. So the way they understood how it works, and they interpreted it and they wrote, and there are people who visit such blogs and rely on such information. So educating or getting educated in a right way, understanding what type of IP can be filed to protect. I've seen even instances where universities or, you know, academic institutions file copyright because it's cheaper than patent, right? If you are going to file a copyright for a technical solution, right, you will get a number, right, and you will not be able to enforce that right. Copyrights and patents are not interchangeable. So one needs to understand that it is not, IP is no different. So I would like to revisit what I said previously. Patents, trademarks, copyright, trade secrets, these are all different types of IP. Or everything is IP. So trademark and IP is not different. Copyright and patent are not the same, right? They protect different types of solutions, different forms. So one should be mindful about that. One other thing that I would like to bring to everyone's attention is the trademark infringement case. Kevin, we worked on that case recently. Would you like to share about it?
Oh, yes. Okay. Yeah. I mean, it's very important when you choose a name for your product or your business to make sure that you do a search and see if anybody else has a similar name out there. And by similar, it's not just the spelling is the same, but you know, it could sound the same, or it could confuse people by the similarity of the way it sounds, not just the way that the letters are arranged, you know, in the name. You know, there's often situations, and Harsh and I have had one recently where somebody like a startup company would choose a name and start a business and use that name. And then the name happens to be very similar to another company's name, and then the other company would write to the startup and say, you know, you need to change your name, and not only that, but you also need to transfer your domain name to us, because that belongs to, you know, that is too similar. You have no right to use that. Then, you know, you have all this goodwill developed. You built your business, your startup using a certain name, and then, you know, somebody comes along and hires a lawyer and writes you a letter, and then, you know, you're in a position where you have to change your name, which is not great if people already know you by a certain name, and they know your product and you've marketed it. So it's very important to do a search first before you choose a name, to make sure that there's nobody out there already with a similar name.
Right, right. Okay, so very quite good on that. So we are discussing all this about, you know, startup and the allied ecosystem with them, in which they are supposed to be nurtured, in which they are supposed to be groomed, right? So here the term comes named as an incubator, right? So here I would like to address a question regarding that. That what do you think? What is the most important role of an IPR professional for startups incubator and incubators?
I think Harsh, you may be best to answer.
Right. So your question is more directed about to the incubators owning the IP. Is that what it is directed to?
Yeah, you can go ahead there as well. But as well, I wanted to know about the roles of incubator. That how that role is important for startups to have this IP thing filed in and protected their rights and all.
See, incubators can enter into service partner agreement with various firms, right? So they can provide, let's say, they can provide the options to the startup, and the startups should be free enough to choose whomever they want. So typically, the way I have engaged with startup incubation centers is I have engaged with them in the capacity of a mentor, where startups have directly reached out to me, sought help, sought guidance, sought advice on certain aspects, and then there is a business relationship that has developed and gone forward. In another type of engagement is I am associated directly with the incubation center, and whenever startups have a requirement, IP requirement, or the startups need some help with IP requirement, they would present the startups with options because they have entered into service agreements with various partners. Let's say 2 or more partners or 3 partners. They can share this information with the startups, and the startups can decide with which vendor they want to proceed. So two different roles. They can either directly work and then refer the startup directly, or provide them with options and then let the startups decide.
Right, right. Got that. Got that.
Thank you, Harsh. My name is Dr. Patni. I head AIC-PRESTIGE, the incubator.
Right.
I'll be very happy to connect with you. And hello, Kevin. Good to meet you as well.
Yeah.
So definitely looking forward to interact with you further and try and see how we can work around the roadmap and interact hugely to make sure that the startups are benefited in the long term, and we get a very distilled and refined mentoring from you for in the benefit of the startups again.
Sure, definitely. Be happy to engage in that capacity.
And indeed, very enlightening and knowledgeable session with you both. Thanks very much indeed, and I hope we are able to continue the relationship further and take this initiative forward in the whole ecosystem.
Yes,
Oh,
definitely.
Great. Thank you.
Thanks very much.
Yeah. I like the questions. They're really interesting. Really, really good.
Yes, indeed.
Mhm.
Thank you so much. Thank you, Sanjeev, to come forward here to address.
Lovely.
So let's move to the next question, which is regarding the same context with the incubators only. So, like in academia as well, when a student or an early stage startup goes for filing a patent, right? As a host, academia or particular incubator will have a host, right? And they will be a co-inventor, or that some sort of policy will be there. So what do you think about it? Like, who should own it actually? And how should the policy should cover this gap?
So should I take it, Kevin?
Yeah.
Okay. So see, typically, it's a good question, and typical engagement when it comes to academic institutes who have incubation centers, there can be written agreements between the institute and the startups that they incubate, right? So either they can only facilitate, and when I say facilitate, the incubation connects the startups with the vendors, the professionals, and the startups take it forward, and whatever IP gets created by the startup can be owned by the startup itself. Now, let's say if there is a scenario where the academic institute is interested in owning either the entire IP or part of IP, they should have an agreement with the startup, right? And it can be on a case-to-case basis. It cannot, it need not be like a blanket agreement by default, where, if a startup gets incubated in, say, X, incubator X, by default, they would be assigning all the rights. On a case-to-case basis, there can be an agreement between the academic institute and the startup, and they can choose to assign the rights and have an agreement defining that assignment, right? Let's say if the academic institute is interested in investing in 60%, right? When it comes to, they have an interest of investing from the monetary aspects as well as owning the rights. They are interested in 60% of the rights. They can mention that in the agreement, and when the application is filed, it can be filed as a joint applicant. So startup as well as the academic institute can hold the rights. The agreement need not be registered with the respective patent office, right? It is only for your reference. It's an agreement between the academic institute and the startup. So let's say tomorrow, either the academic institute or the startup decide to litigate or go to the court, that is when the agreement would come into picture, not otherwise, right? When you are filing, when it comes to owning the IP rights, when you file the assignment, it can be any number of applicants. So it can be just the startup, just the academic institute, or a combination of that, or jointly with additional inventors. Let's say you have collaborated with some other academic institute, right? This is a very common scenario in IITs. I'm seeing that, all the IITs, they jointly work, and then they should have a joint development agreement. It's called a JDA, where they should clearly define who owns the IP rights, what percentage, and whenever they are going to file the IP, whether it would be assigned to one institute or one startup, or it could be a joint ownership. So these things can be defined, and on a case-to-case basis, that can be taken forward.
Yes, definitely. Thank you so much, Harsh, to enlighten us on this, because this is something where Indian startups are, have a very fear of in their mindset, that who will own it and how should I protect it? How should I go with the further plan and all?
So just to enlighten you more, every IP session that I've created in last 2 years, this is the first question that I get.
Oh, okay. Well, let me add something to it then, because what I've found is that if that's the key, if that is a concern that is so important, who's going to own in a collaborative situation, it's often the case that a very good and broad license is the same as ownership. So if the ownership is a heated issue and people are kind of afraid to raise it, or don't want to cause an argument or a fight with the other side, because they don't want to look like they're being greedy and taking everything, and if you give ownership to the other side, the other party, but in return you get a license, because there's two things to talk about. One is the ownership, the other is the license to the party who doesn't own it. So if the party that doesn't own it walks away with a very broad license, they can do whatever they want. They can even sub-license it to others and charge money, to when they sub-license it. It's almost like owning it. So if the other side really wants to own it and they're very wedded to the idea of ownership, and they will not, they have marching orders maybe from their superiors, you must get ownership. Ownership. Don't walk away from there without ownership. If you could sometimes say, fine, you can own it. And then they would look at you. Wow, this guy is being helpful, right? But then you could say, I just want a broad license, if that's okay. And then sometimes you can just agree, on that, So a good license is very, very 95% the same as ownership. What I found is that the thing you can't do with a license that you can do with ownership is if you're selling, your business and that license is going to pass to the buyer, then it's sometimes difficult. You can't transfer the license, to the buyer. But if you're not selling, a broad license can be just as good as ownership.
Yes, that's very great. Thank you, Kevin, to add your additional insights in this. So we are heading to the last question for this fireside chat from my end. So it's more about on a commercialization and investment in IP sector. So let me brief the question. Capitalizing with an IP in software applications is challenging in India. So what are the alternatives and opportunities here in India? Also, would like to add in the same question that how about to invest in IP? What are the tools should be, or how should be the investment strategy should be there to invest in IP?
Okay. Well, when you're investing in IP, the first thing that is done on both sides, actually, from the party itself that is being invested in, as well as the party who's making the investment, should both do this. It's called an IP audit, and you would speak to somebody like Harsh or myself, and we would do an audit. It's kind of like a checkup, like going to the doctor. So we would be checking everything that like a bunch of basic things that you should be doing to see what you haven't done, and what you can do before you start talking to the investor, right? So there are some things you can put in place and fix before you talk to, so that you're healthier when the doctor has the exam, with you. You can put yourself in a healthier position, by fixing certain things. you know. And then the investor, on the investor side, they are looking for problems, like I mentioned earlier. So that is, you know, they're looking for reasons why the price should be reduced, maybe, of when they buy your company. There's, you know, like when you buy a house, you know, you find out that inside the walls there's problems with the makeup of the walls, and the house is not so solid. You know, you don't know that when you drive by and you look at the house, right? But once you start looking in detail, you find these problems, you know. And if you're an investor, you need to know that, because if you're investing in a business and there's lots of problems, and one of those problems is that third parties have a lot of patents that cover what you're doing. And as soon as the buyer, a big company, buys the little company, then the little company may not have been worth the patent owners approaching them, because they don't think they will make enough money from the approach, you know. But as soon as the big investor company buys the little startup company, then the target becomes much more valuable to shoot at. Right, so you'll find people that start shooting at the target when it's much more valuable, you know, to do so. So a big company that's investing in a small company will look for patents of other people that could be brought. So these are all, like, this IP audit is all part of this. You know, it's done on both sides by the buyer and the seller, and you know, looking for things that could affect the IP position. And there's two sides of it. One is the IP owned by the target company. That would be the patents that were actually filed by the software that's actually written by the target, and the trademark that's protected by the target. And then so that's one half of it. And the other half is the IP of third parties. So patents belonging to a third party, trademarks belonging to a third party, software of a third party, like open source, that the startup has used. And are the licenses all complied with? And has it actually all been licensed properly? You know, all of those things. So those are that's what happens in a situation where a company is investing in another company.
Yes, very true. Yes, Harsh, you want to add something?
No, I think Kevin has covered most things. So coming to the part where you said that commercializing IP in Indian scenario is difficult.
Yes.
I don't think so that is the case. There are many factors that come into picture. One is what is the type of IP? Second is the quality of IP, right? Kevin earlier mentioned that we have patent applications with claims. So claims define the scope and boundary of protection. So if your claims are like a kitchen sink where you have thrown in everything to get the patent granted, that is when commercializing it becomes challenging, right? So if it's broad enough, if your claims are broad enough, they are able to, let's say, provide a platform where someone who is trying to build an identical product will infringe that patent. In that scenario, commercialization becomes easier. But if you go with the approach of getting the patent granted, and again, once the patent is granted, it doesn't mean that you are sitting on a gold mine, right? So what actually is claimed, how it is claimed, what is it, very narrow, very broad? If it is very narrow, can it be designed around? Can it be bypassed? Many factors come into picture when it comes to commercialization. And that's how the fee also can be negotiated. So let's say you have a patent which is very, very narrow, although it is granted, enforceable, but it is very narrow, and it can be easily designed around. I can come and negotiate with you and bring down the price substantially, which has been the case in my experience from the patent applications that I see that are filed in India, right? The ones that get granted, the claims run for almost 2 pages, sometimes 3 pages, that can be easily bypassed. So that's when, commercialization becomes difficult, because I have a design around solution for it, right? Why should I come and pay you the money and get a license for it? So
Right.
that's when the expertise and experience of the patent attorney comes into picture.
Right, because what happens when you have a long claim like that in a patent? If you try to, if you want to show any value of that claim to somebody else, the one that lasts for 3 pages that Harsh just mentioned, if you wanted to show that that had some value to somebody else, you would have to do a mapping of every element on those 3 pages to something that the company that you're trying to show the patent to is doing. So you'd have to say, like, we got 3 pages of our claim here. For this first part, we know that you're doing this first part because we found this. For the next part, we know you're doing the next part because we found this in your product. The next part, we found this in your product. So you'd have to do that for 3 pages worth of lines of legal writing, of elements of your invention. That would be so hard to prove that all that company would have to do is change something on page 2, and that's called a design around that Harker was mentioning. You're making a switch, a change, to something, and you got 3 pages of elements that you can choose any one of those to change. So the shorter the better. Capturing the 3 pages is going to be almost worthless.
Yes, true. So thank you so much, Harsh and Kevin, both of you.
Okay.
It was a very insightful session. So I would like to address all the participants that if any queries or any questions you are having at a actual insight level or at a personal level of your startup regarding your venture, like how to go further in your plan to get it copyrighted or have a trademark on it, how to secure it on your site, right? You can connect with these speakers. I'll share their profile in a WhatsApp group as well. They have mentioned the details in a chat box as well. So thank you so much. First, I would like to address the thank you note to you, Harsh and Kevin, both of you. So thank you so much, Harsh and Kevin, for bringing out such an insightful and vibrant discussion on the topic where most of the startups get confused or get bored or something, right? So inventors many of the time do not know on their actual rights. So writing that legal terms where they have been the inventors of the idea as well. Getting deep dive in SaaS in terms of IP and also adding the expertise views surely would help many of the startups founder who are with us, and also will add the value to those who will watch this session later and are looking to protect their rights. As we are going to launch this session on YouTube as well later on. So this was really an engaging session where participants were so keen to understand so much on the domain. We really thanks to you both for making this fireside chat so dynamic. On behalf of AIC Prestige, Headstart Microsoft for Startups, and Niti Aayog, once again, thanks to you for taking out time with us and sharing your views on and thought over here. Thank you, guys.
You're welcome. It was my pleasure, and Harsh as well. We really enjoyed it, didn't we, Harsh? It was great. Yep.
Yes, Kevin, definitely.
Yeah.
Yes. We are so thankful to Harsh as well to bring this up and make this out possible, right? Also, I would add to some points on Headstart and IP-FY as an official partner, and any of the participants, if want to file patents at India or UK, US, can reach out to either us or to Harsh directly for the support in that domain.
Yeah, anywhere in the world, you can reach out to us.
Yes.
We can help you.
Thank you, Bagdasi, for driving the session so wonderfully. And thank you, Harsh, Kevin, for bringing out this particular session in such a more engaging way. And I really love the way you guys have answered all the questions. You have cleared all the doubts. Certainly, this will be really very, very, very helpful for all the people who are watching it. And since most of our sessions goes live on YouTube as well, post editing and all. So ultimately, this is kind of a session which will be always there for people to clear their doubts on such a important topic, right? So really, thank you for giving us this wonderful knowledge and sharing your experience of decades within such a short span of time period. Thank you so much.
Thank you guys once again. Bye.
Yeah.
Bye.
Bye-bye.
Take care.
Bye.
Bye-bye.
Bye-bye.